All right, well, thank you, Larry. Good morning, everyone. My name is Marty Rabinovitch, and this morning, as Larry has mentioned, my topic will be the impact of technology on privacy issues in the workplace. So here's a brief overview of today's presentation. So we'll look at some examples of technologies which can impact privacy rights in the workplace. We will look at devices in vehicles, devices for entry control, payment mechanisms, and some examples of pre-hiring screening. We will then get into some employer considerations before implementing technological changes that may impact on employees' privacy rights, and then we'll end with some recommendations. So let's get right into this. We will start with devices in vehicles, and here we will look at three examples. So we'll start with the Global Positioning System, or GPS tracking. We will look at photographing and recording technology, and we'll also look briefly at breathalyzers on ignitions. So GPS tracking technology, this is technology which can track, record, and report the location of a company-owned vehicle. It can also track other information such as the vehicle's movements, its gas usage, the distance traveled, and the specific routes that vehicle has taken. And in the case that follows here, International Union of Elevator Constructors, this was a case which addressed employee concerns related to privacy arising from GPS tracking. So essentially there were company vehicles in this case that were monitored both when the car was on and off, regardless of whether the drivers were on duty. So in this particular case, the companies had access to company vehicles while they were not at work. And really what the employees through their union were taking issue with was whether the employer should be able to track their whereabouts and what they were doing with the vehicles when they were not on duty. And in this case, the Labor Relations Board did find in favor of the employer. They found that the tracking device was essentially a legitimate way to protect the vehicles which belonged to the employer, and there was a legitimate business interest in doing so, which outweighed the employee's interest in privacy. So in this particular example, the GPS tracking was okay. Photographing and recording, so this technology can be used to monitor the use of company vehicles in real time. So now we're getting into relaying live videos or recording events, both which happen inside or outside the vehicle. There was a case here where employees raised privacy concerns here, and it was the same result. The ruling was in favor of the employer. So here it was an occupational health and safety tribunal which found that the measures developed were okay. They had a legitimate purpose of enhancing the employer's business interest of protecting security of employees because of the risks associated with driving. So we have some victories here for legitimate business concerns of employers. This case is actually not directly related to a device in a vehicle, but this is a bit of an extreme example of when an employer might not be justified in invading on employee privacy rights. So in this particular case called Cowell, the employer implemented surveillance cameras on the ceiling of their office without the employee's knowledge. This was found to be a breach of privacy concerns. It was found specifically by the court to be a breach of the employer's implied contractual term to deal with the employees in good faith. And there was not sufficient justification in the court's view in this case for implementing the surveillance. Breathalyzers on ignitions. So this device would essentially not permit a vehicle to start if the driver's blood alcohol is over a preset limit. So essentially the driver would have to blow into a breathalyzer before the vehicle could be started. Employers have to be a little bit careful here because by requiring an employee to blow into a breathalyzer, you are collecting health information. And the courts have also interpreted this as constituting random alcohol testing. And the Supreme Court of Canada back in 2013 did lay down some criteria which must be met in order for an employer to engage in random drug and alcohol testing. And one of them is that there is evidence of a specific problem with respect to drug and alcohol use in the workplace. So just as an employer, make sure that you're able to prove that if you want to make sure that you have a better chance of being allowed to randomly drug or alcohol test your employees. On to devices now for entry control. So this technology can be used to grant and remove access to each employee to ensure that it's only current employees who are being allowed to enter your workplace. Sometimes employers will use these systems to track employee entry, exit, and breaks. This could be done by what we call biometric systems, which do involve or can involve fingerprinting and retinal scans. Employers can monitor the whereabouts of their employees based on, well, essentially tracking when they sign in and out on their computers. And there have been cases too where employers have required their employees to sign up for some sort of voice recognition related technology. So when we're talking about biometric systems, just to be clear, that's not actually exactly the same as fingerprinting. So for a biometric system, the employer is not actually storing an employee's fingerprint on file. It's more of a computer image. So arguably it's not as invasive to an employee's privacy to have an employer store a fingerprint on file. There is a presumption that dates back to 1965 that unilaterally imposed rules by an employer have to be reasonable and have to be consistent with either a collective agreement or the employment contract. And there was a case here called Metropolitan Toronto and QP Local 79 in which the use of biometric systems by an employer was challenged. So here, in this case, it was actually the employees who were successful. Not so much because the adjudicator had an issue with biometric systems generally, but the issue here was more about the manner in which the system was implemented. The system here was implemented a bit more quickly, I think, than usual, and the employees were not given a sufficient opportunity to express privacy-related concerns prior to implementation of the system. So a good practice for employers, if you would like to introduce new technology which will infringe in any way on employees' privacy rights, is simply to communicate that to the employees and give some time prior to the actual implementation of the system to give opportunities to the employees to at least consider it and raise any concerns. Doesn't mean that just because a few employees have concerns that the employer has to totally change its plans, but if there are any legitimate concerns, it would give the employer some time to address those. The AgroPur case is another example involving entry control devices. So in this particular case, the employer had an issue with what they called buddy punching. So in other words, you'd have one employee who would essentially clock in for their friend who wasn't actually at work. So having a biometric system where you'd have to fingerprint to get in would make that a little bit more difficult. And the employees had issues with that on privacy grounds. In this case, though, the arbitrator said, nope, there's a legitimate business concern here. Buddy punching actually is a problem here, and that concern outweighs the employee's privacy interests. On now to computers signing in and out. So we go back to 2012 for a minute. The Supreme Court of Canada, in a case called Cowell, established that employees have a lesser but reasonable expectation of privacy when they are using workplace computers. But the good news for employers is that is just a presumption, and that presumption can be changed if the employer implements a policy which says, for example, that employees should have no expectation of privacy on their computers. So as long as that is communicated to an employee that they aren't entitled to any privacy on an employer-owned computer or any employer-owned technology for that matter, then the employer should be able to monitor that and use any information to their advantage. Voice recognition technology has also been the subject of at least one court decision here. There's the case here called Turner and Turner Telecommunications. Here, the employer implemented voice recognition technology which allowed employees to use and access the company's internal computer network by speaking commands into a telephone. And if the employees refused to enroll or consent to the program, they were subjected to discipline. The union objected on behalf of its employees. The federal court, though, ultimately ruled in favor of the employer, and they said, well, there's nothing in the applicable privacy legislation that prohibits an employer from disciplining an employee who doesn't consent to the collection of personal information, so in this case their voice. With that being said, employers still have obligations under privacy legislation in terms of what they actually do with the information. So they were allowed to discipline in this case because the employees wouldn't consent, but that didn't absolve the employer, of course, of their obligations with respect to what they actually did with the privacy information belonging to employees. Payment mechanisms, this is something that probably most employers out there are doing, but that you haven't necessarily turned your mind to. Requiring employees to provide you with their banking information, either through a void check or through some sort of pre-authorized payment slip, in order to get paid. This issue actually has come up in labor arbitration jurisprudence, and good news for employers, the arbitrators have said, yes, this is okay. You can require an employee to provide you with your bank account information in order to get paid. In terms of the non-unionized context, the Employment Standards Act is actually silent on the issue. All the ESA really says is that it's open for employers and employees to enter agreements about pre-authorized deposits to a bank. But that being said, I don't really see why, if the issue ever made it to the civil courts, why the courts would be deciding anything different than what the labor arbitrators have decided. And again, just because an employer is allowed to collect that bank account information, the employer does have obligations to comply with in terms of how they actually use that information. So in other words, you can use the information to pay your employees, but probably not much else. All right, let's get now into pre-hiring screening. There are three types of pre-hiring screening that we'll look at here. We've got credit checks, we've got criminal background checks, and we've got social media searches. So the overriding concern here is that when doing one or more of these searches, that the employer may inadvertently discover additional information that may not be directly relevant to whether that prospective employee would be suitable for the position, and as a result could be accused of discriminating against that employee, in particular if they are not hired. In terms of credit checks, there was a decision of the Alberta Information and Privacy Commissioner. In this decision, the commissioner found a breach because the Privacy Commissioner did not see a link between the employer's desire to have a credit check conducted on the employees in question and, number one, their ability to perform the job in question. And the other argument in that case that the employer made was, well, theft is a problem in our workplace, and we think that an employee who has bad credit might be more likely to steal from us. And the Privacy Commissioner said, yeah, we're not really buying that, so no. In Ontario, the issue hasn't really been addressed. There aren't any cases or statutes, to my knowledge, which would prohibit an employer for having credit checks conducted in the pre-screening phase, but the employee still would have to consent to that. You can't just have a credit check conducted just because you feel like it. The employee still would need to consent. Criminal background checks. So in certain cases, if an employer has reasonable grounds to believe that the employee has been convicted of a criminal offense which could materially impact the performance of their job duties, then they might be justified in having that employee undergo a criminal background check. For employees in certain positions, such as supervising vulnerable children, or individuals with a disability, the employer may very well be justified in saying, you know, everyone in those positions has to undergo a new check every year. But if the employer at a big company one day decided to say, okay, well, you know, starting in 2 weeks, you know, everyone, you know, even those who have worked here for 20 years, you know, have to undergo a criminal background check, and I don't care what job you have, that is likely to get struck down as an invasion of employee privacy. There are human rights code obligations. You can't discriminate against an employee based on record of offenses. That's in the human rights code, and there's a case about that. I won't go through that today, but it's on the slide for your reference. Okay, so moving along now to social media searches. So we again go back to 2012 for a minute. In the decision of Jones and Sieg, the Ontario Court of Appeal established a tort which is called intrusion upon seclusion, which in other words would apply if an employer intentionally or recklessly intrudes upon someone's private affairs, and this can result in employer liability if the invasion would be highly invasive to a reasonable person. So how does this all apply? If an employer is conducting Google searches or Facebook searches or other social media searches and is getting results for information that is already publicly available, and they're not hacking an employee's social media passwords or anything, that is fair game. The employer is unlikely to be found liable in tort law. But again, it's the same consideration. You have to watch out, you know, what you might find. I mean, if you discover, for example, that you've got an employee who is now in a same-sex relationship, and you don't hire that employee, and somehow the employee, you know, finds out that you were on their social media page, even if it's completely untrue, well, now as an employer, you may have to deal with a human rights claim for, you know, discrimination, you know, based on sexual orientation. Okay, so you can do it, but just keep the overriding initial consideration in mind. Okay, so to sum up here, let's look at a few employer considerations before implementing technology which will infringe on employee privacy rights. So number one, inform the employee of the systems when they accept the offer of employment and any conditions of employment. For example, a satisfactory criminal record check should be communicated to the employee in the offer letter. When an employer decides to implement new technologies which is going to impact employee privacy, it's a good idea to have policies or amend current policies to incorporate that, and those policies should be communicated to employees well in advance of whatever the implementation date is going to be. The employer should also communicate through policy is a good way the business reasons for implementing that technology and to address any likely privacy concerns. And if the employer has determined that, you know, cutting edge technology or any new technology needs to be introduced to deal with some sort of legitimate business concern, we recommend using the least invasive method possible to try and reduce claims from employees. And finally, some recommendations for employers. So when you're implementing technology in workplace policies, make sure they respect privacy rights of employees as much as possible to maintain employee trust, to ensure good relationships with employees, and to generally try to ensure a harmonious workplace. Surveillance and recording of employees generally should be avoided unless there is a legitimate business or security reason for that. I mean, if you're thinking of surveilling employees, that's a good time to speak to a lawyer. And finally, if you wish to introduce new technologies which will engage privacy concerns, we do recommend that you speak to a lawyer before doing so. That will end my presentation for this morning. We'll skip the last couple there. Thank you.